Hey, what's going on, everybody? I go by the name Michael, and I'm gonna start a couple new videos here. Like I said in a couple of my last video, want to start a little more at the beginning and work our way out from there. It's really important to understand the roots of where we are and how these things come to be and such like that. So today I wanted to talk about the District of Columbia Organic Act of 1871, which is pretty much the incorporation of the District of Columbia and the federal government itself. And pretty much this act, it's pretty much like a corporate charter. It's going into how it's going to regulate itself, its jurisdiction, its powers, things of that nature. So, but the fact that it had incorporated, it has the power to create quasi or sub-corporations in itself too. So that's how you have the state of Wisconsin or the state of New York or the state of Texas. They've brought a corporation in each of the states to make it look like it's the government. In a way, it is the federal government, but it's not the actual state republic government, and it's usurped its power, if not created an illusion of power. And I think that's our main problem today, is a lot of people didn't even realize that all of our government agencies are corporations in themselves. You can check out Dun & Bradstreet for pretty much any entity in itself, any agency, and they are a corporation, and they have shareholders and interest in those. Those shareholders have interest in the policies of these corporations. So you can understand the problem that we could have with that, since it's not really being represented by the people as a whole. So, but I wanted to go into this act with you because I hear a lot of people, they run around saying, "Oh, America's a corporation," and that's all they say. They don't really have anything to back it up, and it is a valid claim, but let's back it up so we can teach other people, and so they can understand too, and also quell the naysayers that don't really believe in some of this stuff. So I like to jump into this act and just go over some of the pertinent information that is in it, and things that really stand out, at least for me. I do recommend you read the whole thing. It's really not too much. It's maybe about 9 pages or so, limited text, so it's not too bad, but definitely something you need to read if you want to understand what's really going on. So why don't we jump into it then? So alright, so this is the 41st Congress, Session 3. This would be Chapter 61. And the title of this chapter is An Act to Provide a Government for the District of Columbia. And it states, "Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that all that part of territory of the United States included within the limits of the District of Columbia be, and the same is hereby, created into a government by the name of the District of Columbia, by which the name is hereby constituted a body corporate for municipal purposes, and may contract and be contracted with, sue and be sued, plead and be impleaded, have a seal, and exercise other powers of a municipal corporation, not inconsistent with the Constitution and the laws of the United States and the provisions of this Act." So basically what it's saying is this federal government can create its own laws and all that stuff, but basically they're incorporating themselves. They're becoming a corporation, and they're being granted by the Senate and the House of Representatives. And what they're going to go through in this act is its corporate charter and how it's supposed to act and things of that nature. So we'll move into some of the interesting things in this document. This is one interesting thing right here. This is talking about the oath of the members of the Legislative Assembly. And for people that don't know about the Legislative Assembly, it's not even in existence anymore. It was abolished in 1874, 3 years after this act. And is my contention that basically this legislative assembly merged into the Senate and the House of Representatives, basically merged with the Congress, and pretty much a takeover, a corporate takeover of a de jure government. I haven't yet found the facts on that, but I can only assume that once you start getting into this act, you can understand how I come to that conclusion here. So, as it says in here, I do solemnly swear or affirm that I will support the Constitution of the United States and will faithfully discharge the duties of the office upon which I am about to enter, and that I have not knowingly or intentionally paid or contributed anything or made any promise to the nature of a bribe to directly or indirectly influence any vote at an election or at which I was chosen to fill the said office. I have not accepted, nor I will accept, or receive directly or indirectly any money or other valuable thing for any vote or influence that I may give or withhold on any bill, resolution, or appropriation for any other official act. Now I'm just going to stop right there, because what do we see in Washington all the time? We see lobbyists, and we see a lot of these officials taking in money for their campaigns. So it's in direct violation of their own corporate charter here that they're not supposed to be taking any money or anything of that nature. And there is a punishment for it, and we'll kind of go into that right here. This is the next part of it. It says, any member who shall refuse to take the oath hereby prescribed shall forfeit his office, and every person who shall be convicted of having sworn falsely to or of violating his said oath shall forfeit his office and be disqualified thereafter from holding any office or profit or trust in said district. And the next page it says, and shall be, let me get this for you, and shall be deemed guilty of perjury, and upon conviction shall be punished accordingly. So basically it's saying if any of the officials go against the Constitution, they are in direct violation of their oath, and they should be punished accordingly, and I doubt that's ever really happened, ever. So, moving on, we'll go to section 16. And be it further enacted that the district shall never pay, assume, or become responsible for the debts or liabilities of, or in any manner give, loan, or extend its credit to, or in aid to any public or other corporation, association, or individual. And we talk about this section, we're thinking about the quasi-subcorporations that this federal government has instilled in every state, acting as the government itself. The federal government extends credit down to the states all the time for different projects and things of that nature, so direct violation of this part of their charter as well. So we'll move to 17. And be it further enacted that the legislation shall not pass special laws in any of the following cases, that is to say, for granting divorce, regulating the practice of courts of justice, regulating the jurisdiction or duties of justice of the peace, police magistrates, or constables, providing the changes of venue for civil or criminal cases, or swearing the impaneling juries, remitting fines, penalties, and forfeitures, the sale or mortgage of real estate belonging to minors, or others under a disability. I'm going to stop right there. What do we see wrong with that? We see regulating the practice of courts of justice. Federal procedures for civil cases, federal procedures for criminal cases. The list can go on and on as far as regulating practice of courts of justice. As far as regulating the jurisdiction of police and police powers, we see that all the time through numerous acts after this. So violating that part of their corporate charter as well. Remitting fines, penalties, and forfeitures, or the sale or mortgage of real estate. Might not be belonging to minors, but we see that as well. And then we go a little bit further. It says changing the laws of descent, increasing or decreasing the fees of public officers during the term of which said officers are elected or appointed, granted to any corporation, association, or individual any special or exclusive privilege, immunity, or franchise whatsoever. So obviously we see corporations all the time being granted special exclusivity, whether it be a fictitious government entity or just anything in general, tax credits or such things like that. So that's being denied as well in their corporate charter here. Section 18, be it further enacted that the legislative power of the district shall extend all rightful subjects of legislation within the district, consistent with the Constitution of the United States and the provisions of this act, subject nevertheless to all the restrictions and limitations imposed upon states by the 10th section of the first article of the Constitution of the United States. But all acts of the legislative assembly shall at times be subject to repeal and modification of the Congress of the United States, and nothing shall be construed to deprive Congress of the power of legislation over the district in as an ample manner as this in law has not been enacted. And as we look at this one, although the legislative assembly of the District of Columbia is not has been abolished 3 years after this, I see the infiltration of all of these parts of the corporate charter in the Congress, the de jure Congress itself. And it's kind of funny because it just kind of flips it over. It says Congress doesn't have any power over the District of Columbia, and they have to follow the Constitution. But obviously that's not the case. They flipped it, infiltrated it, and went about their ways. So let's jump to Section 20 here real quick. And be it further enacted that the legislation assembly shall not have power to pass any ex post facto law, nor law impairing the obligation of contract, nor to tax the property of the United States. So do we not see property being taxed by the United States through the quasi sub-corporations of the federal government? I see it. And I also see impairing of obligations of contracts as well. So I've had my obligations been impaired, and so there was supposed to be a limit to this assembly, and I think they had to get around this limit by infiltrating Congress itself. So I think that's one of the interesting things of this act. We'll go to 25 here. Section 25 says, and be it further enacted that the judicial courts of said district shall remain as now organized until abolished and changed by act of Congress. But such legislative assembly shall have power to pass laws modifying the practice thereof, and conferring such additional jurisdiction as necessary to due execution and enforcement of the laws of said district. Now, obviously we see that the district has found ways to such additional jurisdiction so they can move their enforcement of laws on all the states themselves. Very interesting right there. Move down, we'll do these section 28 here. And be it further enacted that the said legislative assembly shall have power to create by general law, modify, repeal, and amend within the said district corporations aggregate for religious, charitable, educational, industrial, and commercial purposes, and define their powers and liabilities. And the powers of corporations so created shall be limited to the District of Columbia. Now, when you have the District of Columbia throwing corporations out in all the states as states of, you can see how they can get in every nook and cranny, because this says that they have the power to create a corporation, but also modify, repeal, and amend, and regulate regulate and define the powers and liabilities of all those corporations. So that has granted them power to be able to do that. Move down to section 31 here. Let's move all the way down, get this page for you so you can read it. And be it further enacted that the government, secretary, and officers of the appointed pursuant to this act shall, before they act as such, respectively take and subscribe an oath or affirmation before the judge of the Supreme Court of the District of Columbia and some justice of the peace and limits of the district, duly authorized to administer oath and affirmation by the laws now enforced therein, before the Chief Justice or some associate judge of the Supreme Court of the United States, to support the Constitution of the United States and faithfully to discharge the duties of their respective offices. Now, when we look at this corporate charter, it's been strewed all the way through here that they're leaving remedy for the sovereign people of America. Each official has to abide and support the Constitution and discharge the duties of their respective office. So There's always going to be remedy in every law, and these are some of the remedies in here. And this also extends to civil officers, as it says. And all civil officers in said district, before they act as such, shall take and describe a like oath and affirmation before the said governor or secretary or some judge or justice of the peace of the district, who may duly commission and qualify, and before the Chief Justice of the Supreme Court of the United States. So that just extends to pretty much every policy officer, every officer in general that's in quote-unquote government. They have to abide by the Constitution as well. It's in the corporate charter here. So, and just one more, same thing, throwing it a little bit further, is the Constitution, all the laws of the United States, notice it doesn't say acts, which are not locally inapplicable, shall have the same force and effect within the said District of Columbia or elsewhere within the states. So if you didn't get it clear enough yet, Constitution is still the law of the land. There's no way that anyone can get around that. All they can do is incorporate, and if you don't know they're a corporation, you're not acting in corporate capacity, and not know how to get to the Constitution, you're not going to get it. But the remedy is there. You just need to know how to get to it. This is interesting right here. We have private buildings clause. They shall make all necessary regulations respecting the construction of private buildings in the District of Columbia and subject to the supervision of the Legislative Assembly. So with these quasi-governments, these sub corporations, they're now able to regulate all private buildings that are subject to it. So, and one can only imagine that if they have regulations over private buildings, they have regulations over private property as well. I haven't found it in this act, but I can see how they can jump to the conclusion that they have that right and authority as well. So we're almost done here. This is just some interesting part of our history right here. Section 40, and be it further enacted that the charters of the cities of Washington and Georgetown shall be repealed on and after the first day of June, A.D., June 1871, and all the offices and said corporations abolished at that date. The levy court of the District of Columbia and all offices connected therewith shall be abolished on and after the first date of June 1st, A.D., 1871. Now, Washington, Georgetown, these are part of, I think that was in Washington County, I think that's what they called it at the time, but these cities were already corporations, and at that point our federal government was a corporation to begin with. So we need to understand that and move forward with it. There are corporations for the federal government to move business and all that, so they do have their place, but if they start infringing on the rights of the people, that's when we all have problems. So we jump down a little bit more, and it says, upon the repeal of the charters of the cities of Washington and Georgetown, the District of Columbia, let me get this for you, the District of Columbia be and is hereby declared the successor of the said corporations, and all the properties of said corporations, and the County of Washington shall be vested in the said District of Columbia, and all fines, penalties, costs, forfeitures, which shall now by law be made payable to the said cities, respectively, and said levy courts shall be paid to the District of Columbia. So that's basically saying that our federal government that we had before is successed over into this District of Columbia. So that pretty much concludes the act. So yeah, I mean, that's where we're at. I think that's pretty much how we got to where we are now. I think that's our proof of the federal government being a corporation even before this act. So, you know, like I said, there's the proof in the pudding. America is a corporation, and they just instill their quasi sub corporations all across the states and make them look like entities that are actually de jure governments, but in fact they actually are municipal corporations. And municipal corporations are charters, and they're instilled by sovereigns, and we are the sovereign people here, and we've installed these charters, so we need to understand where we stand in this whole situation. So yeah, that's the District of Columbia Organic Act of 1871. I definitely recommend you reading it, getting a little more into it, and see what's going on. But that's definitely proof in the pudding that we are a corporation, and we need to work from there. So I'll do some more videos in a little while, but like I said, I want to start from the beginning. We'll work our way forward, and we'll go from there. So just want to let you guys know, keep it up, keep researching, keep an open mind, and never surrender. So peace.